Okay, good morning. I'm Kerry Vander. I'll be presiding over the oral arguments today. The other members of the panel, Judge Brian Lambert and Judge John Harris. Each side will have 20 minutes. Ms. Pohl, if you want to tell me how much time you wish to divide between opening argument and rebuttal, I'll try to help you in that regard.
Yes, I'd like to reserve 4 minutes, please.
Okay, and did I pronounce your name correctly or not?
Yes, pole, like fishing pole.
Okay, thank you.
Okay.
You should have a clock on your screen, which can also assist you. These oral arguments are being live streamed so the public can watch them on YouTube. And with that, Ms. Pohl, you may proceed.
Thank you. May it please the court. I'm Beverly Pohl with Delson, Mullins, Broad, and Cassell, and I represent the appellants who are the successor, personal representative, and numerous beneficiaries of the estate of Gino Pellucci. A little background before I launch into my arguments. In early 2013, Gina Pellucci, as a creditor, was paid in full for the $7 million claim that she made on the estate and signed a release relieving the estate of any further liability. 1 year and 9 months later, she filed a petition to amend that already paid claim, contending that there had been a miscalculation and that it was a defect in form, the original one, and that under the rules in the probate code, she should be permitted to amend her claim. The petition to amend the claim never mentioned the release. Nonetheless, over objection in 2015, the judge granted that relief, and on appeal, this court reversed, saying it was remanding for an evidentiary hearing to determine whether there was any basis to set aside the release. That hearing was held, and we are back here today. The judge again ruled in favor of Gina Pellucci in an order that virtually ignored the evidence that was presented at the evidentiary hearing, and we think misinterpreted several provisions of the probate code.
Let me ask you this. What do you believe our standard of review is on the judge's finding as far as whether there was inexcusable inexcusable neglect, if you would?
Yes, we've set this out in some detail, particularly in the reply. We think that it is de novo because the evidence at the hearing was undisputed. And under an old Florida Supreme Court case called Holland v. Gross, which is still good law, when the evidence is undisputed, the trial judge can't ignore that evidence. And the question is whether, as a matter of law, the judge presented the evidence correctly. And here we think he did not. Let me explain what happened. Gina had the burden at the hearing to show that this mistake that her lawyers made was not the result of an inexcusable lack of due care. And those two lawyers testified at length and were candid about the lack of due care that they gave to this task. Now, the judge said in the order, which, by the way, that portion of the order was drafted by Gina's counsel, that it was a miscalculation. That was the only thing. There were two things in the order pertaining to the evidence. The judge said it was the miscalculation, and the judge said that Mr. Ehrig was basically busy doing other things, putting out a lot of fires. But there was so much more testimony, and it was so damning. It really can only be described as an inexcusable lack of due care. And what happened was Mr. Ehrig represented Gina Pellucci in many other matters, but he referred this task of preparing the statement of claim to his partner, Miss Van Sambeek, because she was a specialist in trust.
Let me ask you this. One of the disputes in the briefs was in assessing whether there's inexcusable lack of due care, do we factor in that the mistake, if you would, was made by an experienced lawyer? Do we apply that standard, or do we apply any type of lawyer, or do we apply a reasonable person? And more importantly, is there any case law which says how you're to evaluate inexcusable lack of due care, as far as what type of person who committed the mistake, if you would.
No, but if you look at the cases, I think the courts are less tolerant of lawyers who don't exercise the kind of professional diligence that they're supposed to exercise. And what happened here was Miss Van Sambeek treated this very casually. I mean, in a matter that involved multi-million-dollar claim against the estate, there were 2 documents that set forth the amounts that Gino Paolucci had owed to his daughter. And she never looked at those documents. She says she looked at the mediated settlement agreement, but not the provisions on repayment. She didn't look at them. How she determined what needed to be submitted to the court was through a conversation with Mr. Ehrig, and she did nothing more. It's really shocking.
If we can look at it as being lack of due care by an attorney, do we look at it as an experienced attorney or inexperienced, or just reasonable standards for lawyers in general?
I'm not sure that it makes much difference. Anybody with a law degree has a responsibility to act with diligence. And I do think that when a lawyer has a significant matter, when a client has a significant matter and takes it to a lawyer who is a specialist, or somebody who's represented them for a long time who refers it to a specialist, they expect a high level of professionalism, high level of diligence, and she didn't get that here.
Well, let me ask this. Let's say her testimony was, your position is inexcusable because she didn't look at any of the documents. She just said, well, in essence, 10 million minus 3 million is 7 million, and then there's the set off that everybody agrees to. Well, let's say she had looked at all these documents and then she just messed up. She says, yeah, I read all that, and I guess I just misinterpreted it all, and I told Gina that this was what was owed, and off we went. I guess my point is, where does it become excusable versus inexcusable? What fact do we take out of here that would translate this case, in your view, from an inexcusable to an excusable neglect case, of which your side, I think I understand, at least on the first argument, would lose, right? Do you follow my question? Your position is inexcusable neglect. We don't have to get past any of that.
That's correct.
Okay, and that's based on the facts of this case. What would be excusable neglect here in your view?
Had she looked at the documents, had she contacted the accountant, even spoke to Gina about it, and made a mathematical error, this might be a different case. But not only did she not look at the repayment terms in the mediated settlement agreement, but when the check was transmitted from the lawyer for the personal representative and made 8 references to a note, and her testimony that she said to herself, I didn't know there was a note. And so she made no effort to look at the note, and the note is the document that describes specifically terms of repayment.
Are you
no effort to look at it.
You familiar with the Rock Springs Land Company case, where it's a 4th DCA case, but it actually was out of the Orange County Circuit Court, which would be our jurisdiction now. But that being said, where the president of the company looked at the wrong amortization schedule and said, okay, you owe me $446 instead of the $2561, and the buyers paid that and said, okay, good, we're all done. And then Rock Springs was able to get the relief, saying, no, you are entitled to $2561. Tell me how that case isn't as closely on all fours here, other than, aligning to what Chief Judge Evander was saying, that was a lay person president of the company and not an experienced attorney.
And that's the key difference. Experienced attorney has a different level of expectation of due diligence. The amount was much different, although I don't think that's the key. I think that it's a non-lawyer, and the standard for what's excusable or inexcusable is different for a lawyer. That's the main distinction between that case. Plus, that case was in 1973. And I think that this body of law has evolved over time. And even though the facts might be similar back then, I think the expectation for how a lawyer conducts himself or herself has evolved, and the courts have not been tolerant of lawyers who don't do what they're supposed to do. I think the BMW case is illustrative of that, and many subsequent cases cite BMW because the lawyers just failed to do what they should have done. And they came back later and said, oh, we overlooked this. And the court said, no, that's an inexcusable lack of due care. That was part of your
If
job.
I'm following up your answer, let's say Mrs. Palucci, Gina Palucci, had no attorneys involved, and she's just the one who filled out the statement of claim by herself and sent it in and got paid. And then a year or so later, when her accountant says, geez, Gina, what happened to that other 1.7 million? And then she then hires an attorney who proceeded as we now are proceeding now.
I think that would,
in your view, that would be more excusable because she's a layperson. Is that?
I don't think so, because she was the party to those documents. She knew those documents existed. And
well, that was the same thing with Rock Springs. It was the president of the company who was a party of the company who gave the wrong amortization schedule.
It's true, but even if it was inexcusable on those facts, those aren't our facts. And even if this court, for some reason, should find that the release could be set aside, that still takes us to the probate code and the timing bars that exist in this case that should have required the petition to be denied. And I'd like to move to the end of the probate code analysis.
Before you do that, Ms. Pohl, let me ask you a question. I think you stated earlier that the judge made a finding in his order that this was the result of a miscalculation. Is that a legal conclusion or a factual finding? And what deference do we give that conclusion?
It's a legal conclusion because the evidence was undisputed. And it so ignores the testimony. I mean, the testimony, when you read it, is almost painful to read because they admit over and over what they did not do. It's very
miscalculation. If we agree with the judge that it was a miscalculation, this I think gets into your next argument. Then changing the form, is that a change in form or substance? Changing the claim form, trying to amend the claim form.
Courts have said that a change in the amount is the amount of substance because it changes.
Unless it's a miscalculation, right?
It affects the substantial rights of the party. But, even if we've talked a lot about whether this was form or defect in form or substance and whatever, but I think you have to look at 733-710, which
let me ask you about that. I mean, I get, all right, let's say there was no non-claim statute in this case. In other words, they didn't file a notice of creditors. And then on the last day of the 2-year period, they file a creditor files a claim for $1,000 and it should be $10,000. And it's just a clerical error. The PR sees that, and the day after the 2-year run sends a check for $1,000. Creditor gets that and says, oh my goodness, I put the dot in the wrong layer. It should have been 10,000. Everybody agrees that I'm owed 10 grand. If I'm understanding your argument, if they came back on 2 years, 2 days after the death of the decedent, again, no non-claim statute or no 3-month thing, you would say they're out of luck if I'm understanding your argument.
I would say it, and the Florida Supreme Court would say it, because the statute has one exception, which is if it says this 2-year deadline does not apply for claims that have not been paid. And the only way to read that is in the inverse is that if the claim has been paid, the deadline applies.
So it's a clerical error and the PR says, good luck. Hey, what do you know? We just got a break. I'm going to send the $1,000 check. I know we'd owe 10 grand. And as soon as they pay it, and then the next day, the creditor says, oh my goodness, wrong. Let's amend my claim. You'd say your interpretation of Supreme Court decisions is that they're just out of luck. They can't amend it to correct the clerical error. Is that, I'm not criticizing. Is that what you're telling me?
That is our position based on two things: the language of 733-710 and the May versus Illinois National Insurance case, which is very complex. But if you get to the end of that case, they find that the failure to comply with 733-702, I believe, completely bars the claim against the estate. It was a harsh result there. And the parties have disagreed about the interpretation of that case. But if you go and look, it was a 11th Circuit certified question. And if you go and look at the subsequent 11th Circuit decision, it's clear that they interpret it to mean that the person had no claim against the estate because they hadn't met the deadline in the statute. It can have a harsh result, but equity does not trump the law. We've made that clear in our brief, and these statutes are firm. And although the 733-702 can be amended, there was never, can be extended. It's only for certain reasons, such as fraud. And so there was no amendment due to any kind of fraud here.
Does our footnote 4 in the Shearer case suggest that this is, if there's a miscalculation in the amount of the claim, and it's not for some separate services like was in that Medicaid case, Shearer's case, that's just a defect in the form and not substance? Is that, I grant you that's dicta, but isn't that what we were saying in footnote 4 there?
I must admit, I don't have footnote 4 at my fingertips, but this is not a miscalculation. I think that's the essential error that the trial court made. This was a repeated misjudgment, the lack of exercising any due diligence in carrying out this task, and completely ignoring the responsibility that they had to this client. You don't make a multi-million-dollar decision based on a conversation with your colleague in the hallway and then submit this claim without ever looking at the underlying documents. I think that's shocking.
Let me ask you a question on a slightly different topic. What do you believe the personal representative's duty was, if any, to a creditor in general? When the amount of debt, at least the judge found here, that it was not disputed, the personal representative knew it should have been 8.7 or 8.8 million rather than 7 million.
Not that it should have been, it could have been. I want to make a distinction here between what Gino Paolucci owed to his daughter and what the estate owes to his daughter. They're two different things. The estate has a duty to creditors to protect the assets of the estate and to assess a claim to see if it's a valid claim and to pay it. A personal representative has that duty to exercise those tasks with good faith and due diligence, and he did that. She didn't say, pay me what's owed on that contract. She said, I want $7 million. And he immediately gave that to legal counsel when he received it, and the letter from counsel transmitting the money said, as per the claim, here's your $7 million.
Okay, you have about 3 minutes and 10 seconds, so I'll save the rest of the time for rebuttal.
Yes.
Okay, thank you. Hey, Mr. Bai.
Good morning. May it please the court. I'm Jonathan Bai, counsel for the appellee Gina Paolucci.
Let me pick up on the same question, follow up to the question I just asked. You suggest in your brief that there's a fiduciary duty under the statute, but is a duty to preserve the estate assets for the benefit of the beneficiaries and creditors different than a duty to tell a creditor you screwed up on your claim?
Well, those may be different duties, but that the law as to what the duty is of the personal representative does not distinguish between those. It simply
But does the statute use the term fiduciary?
The statute, as well as the case law interpreting it, the statute actually refers to I'm sorry, I'm not finding it right now, but that is undisputed that there is a fiduciary duty owed, whether it's through the case law or the language of the statute itself. And it is not so refined as opposing counsel would make it, that it only, that it somehow doesn't cover this particular.
Well, you'd agree if they had a creditor had a personal injury claim and they didn't call the best witness to bolster the creditor's claim, that the PR would have a duty to say, oh, you need to call this witness to really get the damages you're entitled to. And you'd agree, for instance, in a unliquidated damage claim that the PR would not have an obligation to help the creditor get all the creditor might seem to be entitled to. So why would it be different on a liquidated damage claim?
Well, in this case, we're not talking about giving legal advice. We're talking about a factual matter, and disclosing factual matters is different than advising the creditor as to legal strategies.
Well, there's an interpretation of the note involved as far as when the interest is to be calculated, right?
No, well, there's no dispute as to what's called for here. And Mr. Nelson, as the, I think it's
I
important.
think there could be cases where the note language was more ambiguous, right?
Certainly.
So in that situation, would the personal representative have to say, you know, there's good case law out there for you that you haven't found, but so I'm going to continue to deny your claim? Or
Well, that's a closer question, certainly, Your Honor, than we have here. But I also think it's important to note that the court does not need to reach the fact that there was a breach of fiduciary duty under the mistake portion of the analysis. I think under the equitable estoppel argument, which is our Tipsy Coachman alternative argument, I think the court does need to find that there was a duty in order to find a breach of or to apply the doctrine of equitable
But
estoppel.
as to the equitable estoppel document, that your opponent in reply brief cites to the Castro case, 2004 case out of the first DC, saying in a probate context, estoppel requires a showing of affirmative deception. There's no showing here by the PR. They just didn't open their mouth, or his mouth, I guess.
Yes, that is correct. The Castro case does have that language. Of course, that's a first DCA opinion, not binding on this court.
Right.
And I would note that the Castro, for support for that, cites Rinker, which is not a probate case at all. So it just comes up with that statement out of the air. And in that case, there was no duty of an omission. So it's dicta in that sense.
Well, let me ask, as to our standard of review here, the Holland v. Gross case that your opponent cites. I mean, that seems to me to be applicable here. There's not really disputed issues of fact. Everybody agrees what happened. And it really is a label is it excusable or is it inexcusable? And I analogize this to, let's say you just gave a stipulated statement of the facts to the trial judge saying, we all agree with the evidence is, Judge. We don't need to call a bunch of witnesses and take 2 days of your time. Here's what we all agreed happened. Make your call. And the judge writes the order that he wrote, and it's up on review now. We wouldn't give deference to the judge's findings. We would be looking at the same piece of paper or statement of the evidence that he looked at, and we would then apply de novo, wouldn't we?
Well, it depends on what the question is. Here, the question is, you have a judge sitting in as a probate judge. So it's an equitable matter. It's in an equitable court to start with, applying an equitable doctrine. And therefore the issue is, and it's an equitable doctrine that they agree it's a discretionary application of that doctrine. So the question for this court is whether the exercise of his discretion under all of the facts and circumstances was incorrect. It's not a factual finding matter. Holland was a factual finding. Was a loan made to a corporation or to an individual? That's a fact finding. And all the cases they cite on this point are the traditional fact finding. Here, it's not a question of...
But the same equity is involved. I mean, we all see the same thing. You know, Gina should have filled out a claim for this. Her lawyers didn't do it right. She trusted her lawyers. The PR paid it. A year and a half later, her accountant says this. She's now out $1.7 million if the release is not set aside. And so we get all, we get all the equity to it. And isn't it an application of if it's a unilateral, I mean, if it's a unilateral mistake, doesn't that cause you to lose the case? Inexcusable neglect.
Well, if under all the facts and circumstances, the court that makes the decision decides that the doctrine of unilateral mistake should not apply for whatever reason, then yes, she would lose. But I haven't established the rules for review. I don't establish the rules for when a court sits in equity applying equity. But the traditional rule is that when a court is making an equitable decision, this court, the Court of Appeals, defers to that because the court is the one that has the superior vantage point.
So let me make sure I'm following through correctly in my mind what you're saying. So if the judge below says, this is inexcusable neglect by Gina's counsel, it meets all the criteria, the BMW case or whatever, but it just ain't right. It ain't fair. It's inequitable. I'm going to ignore the unilateral mistake doctrine and I'm going to give relief to Gina. You're saying we should just summarily affirm that. Forget about the probate code arguments for a second, but just on that issue.
No, I mean, it has to be exercised the reasonable discretion, and the abuse of discretion standard, is still a standard for this court to review. And if he found that it was an inexcusable mistake and yet goes ahead and applies the doctrine, that would be error. No question about it.
Okay, well, that would be an abuse of discretion.
I agree there are some situations like a motion for continuance or how much alimony to give or whatever. Even if you have facts in dispute, there might be some discretion. I don't know if it's the same level of discretion we give in other circumstances, but getting to the underlying question, are there any disputed facts in this case?
I think that on the specific facts that the court mentions, no, I don't think there is a dispute as to those. But the difference is this trial court was dealing with this matter in this probate action for 8 years by the time it came to this hearing, dealt with these parties in 36 different proceedings, knows the ins and outs of these parties.
I don't know how that matters. I mean, I know that sounds good, but I mean, let's say the case came to the trial judge on competing motions for summary judgment, saying we all agree what the facts are. We think it's inexcusable. You think it's excusable, and therefore we shouldn't set it aside. Okay, the judge is going to rule based on the undisputed facts. The history of the case is really all not that germane to the specific issue here because we all agree what happened, and it's, isn't it? I mean, I guess
I disagree, Your Honor. I think the history of the case is important for the court in equity to decide what's fair, and that's the underlying
you're
part
losing me on that.
equity.
Go ahead.
I'm sorry, what?
You're losing me on that, but go ahead.
Well, it's an equitable decision. The definition of equity is fairness. The trial court, in looking at all the facts and circumstances here, decided that this was the equitable thing to do.
Let me ask you this, Mr. Vai. In determining whether there's excusable lack of due care or inexcusable lack of due care, do we view the fact that this is an attorney differently than if this was a non-attorney?
No, I mean, there's nothing in the cases that suggests there's a different standard applied because there's an attorney involved. I think there were 7 cases that the parties cited that involved attorneys, and there is not a hint in any one of those that you hold the conduct of a lawyer to a higher standard. And I would just point out that in those 7 cases, and only 2 of them, was the mistake found to be inexcusable. And I think it's important to note what the facts on some of those cases. An attorney releasing the lien of the wrong client was not inexcusable. An attorney paying out more than it should have from the trust account, not inexcusable. An attorney failing to include an intended party in a settlement, not inexcusable.
Mr. Vai, what about the supplemental authority that was just filed, the case out of the 4th, where a non-attorney who fails to look at the public records and find a superior lien, that was inexcusable?
Yes, but that's under a different standard than we're applying here, although the court referenced at one point unilateral mistake doctrine that was really in dicta, because this involves setting aside a judicial foreclosure, and there's special law as to when you can set aside a judicial foreclosure, and it's not that there's an inexcusable or an excusable mistake. There must be a mistake imposed on the complainant in connection with the sale itself. And that's what the court found.
Is a foreclosure proceeding an equitable proceeding?
No, but a judicial sale proceeding.
No, foreclosure case itself, so equity, right?
No, I don't believe so, Your Honor. I'd say that's a matter at law. It's governed by statute. I assume that it was a judgment, it was a mortgage foreclosure, a judicial foreclosure. I believe that would not be. But the court, the standards that it applied were different than the unilateral mistake standard.
I can, Mr. Bott, let me take you back to another equitable argument you made on your tipsy coachman, which frankly confuses me a little bit. On the equitable estoppel, what are the elements of equitable estoppel that you'd be relying on?
There's a representation which may be silence when there's a duty to speak. And we say there was a duty to speak because of the fiduciary duty. There's reliance.
There has to be reliance on that representation or that silence.
There's reliance on that silence.
Right, that causes Gina to change her position.
Well, the reliance on the silence was paying or accepting the payment without.
But what was her position? Because she has to change her position in reliance on that misrepresentation. What was her original position? And how was it changed based on the silence?
I do think it's important to point out that in the statement of claim.
That's not what I'm asking.
Well,
what was her original position?
I'm sorry. In the statement of claim, she asked for payment of the full amount due. She then also stated the amount and misstated the amount. So her position was and always has been full payment of what she was due.
Well, how did she change her position then based on silence?
She changed her position by accepting the $7 million based on the silence.
Her position is still that she's entitled to the full amount.
Correct.
So her position hasn't changed.
Well, she changed her position by signing the release and accepting the $7 million. That's how she changed it. She didn't understand she was changing her position, but that's what she did.
Was she required at any point to file any kind of motion with the court asking to have that release set aside?
No, she filed a petition to amend, which had the same effect.
Under what theory?
Under what theory? Because she was seeking to amend. She was seeking permission from the court to amend. The court had to agree with it.
It's already been satisfied. The claim doesn't exist anymore. How do you amend it once it's gone? It's been released and satisfied.
Well, that gets to the statutory arguments, which clearly provide that you can amend at any time and took out the restriction that you couldn't amend after payment was made.
Well, it doesn't say anything about when it's satisfied and released.
Well, it used to say.
The earlier version said you can't do it after payment, but it doesn't say anything, neither version, about whether you can amend it after satisfaction.
That's true. That's
So
true.
the claim is released. It's not there. How do you amend it? It's not there anymore. It's gone.
Well, that was the reason for bringing the motion, and that was clearly what they raised the issue right from the start as to whether the release barred it. That's been litigated. It certainly was part of the case. There was no need for her to raise that affirmative defense, and that's been in the case since the beginning. I do think it's important to remember that Mr. Nelson was a party to the original settlement agreement. He knew very well what was due. This wasn't just a conclusion of the trial court. Mr. Nelson admitted that he knew that there was a discrepancy between her stated request for full payment and the statement of what that number was in her statement of claim. And he chose to say nothing. That, whether he had a fiduciary duty or not, I think is a key fact under the unilateral mistake doctrine. As I was mentioning, there are numerous cases where attorneys have made egregious mistakes. Those have not been found to bar the remedy.
Well, let me ask that. What would be in the context of this case? What more would your side have, your Gina's attorneys had to have done that, in your view, would take this to be an inexcusable neglect or inexcusable lack of due care?
Again, I think it's an all facts and circumstances test for whether you apply the doctrine, and so that it would depend on the circumstances. They rely heavily on the BMW case, and in that case, I think certainly one of the key factors was there is no evidence.
I agree it's based on the facts of the case. I think that probably is most cases. But all right, so your position is the trial judge is right. It's, whatever, the error is excusable, correct?
Yes.
Okay. But you do agree there's a doctrine that unilateral mistake can set aside, unilateral mistake requires inexcusable neglect. And that's what your opponents is arguing, that's actually what happened here. So my question, maybe I'm not asking it very well, is these facts you and the trial judge agree are excusable. What other fact would your side or Gina's attorneys have had to have done that in your view would take it to a level of inexcusable neglect?
Again, I think one factor would be, as in the BMW case, if the other side had no reason to know that it was a mistake. I think that makes it inexcusable under the circumstances. Okay,
so if Mr. Nelson was Mr. Smith, who happened to be Mr. Palucci's PR because he met him, the last week of Mr. Palucci's life. I'm just throwing out facts here. And Mr. Smith didn't know anybody, and he didn't take any action here. Then your side's behavior or your Gina's attorney's behavior would be inexcusable because you can't pin anything on my hypothetical Mr. Smith.
I think that makes it a lot harder case. Yes.
Okay. Anything else?
That would make it inexcusable?
Yeah, to me, that's the nub here, is there's undisputed facts. Is this excusable or inexcusable neglect? Whatever level of deference we give, we'll decide amongst ourselves, but we all seem to agree that inexcusable neglect is problematic for your side getting relief or keeping your relief. And, you say we're not at that level yet. And I'm just exploring, what else would have to happen for, in your view, saying, if we'd have done this and this as well, and I know it's not you, that would be inexcusable. And what are you going to do?
Well, in the BMW case, it was the court, including Dale, the 4th District most recently, we provided supplemental authority on that in June. Focus there on that the attorney had made an assumption in not including in the offer of judgment that everyone understood that was a term. So if there was some strategic element to this, if there was some assumption being made that it was all right to have that difference there, something which frankly makes it more inequitable to allow or to not correct the mistake.
Well, if I understand the facts, and I'm trying to wrap myself around the fact how this is not inexcusable, saying we're settling a claim of millions of dollars, and I don't look at the underlying document that supports the basis for the claim when I both fill it out and when I accept the money. Boy, that seems inexcusable to me. I don't know.
I think there are two things here. One, there was a promissory note, but there was the mediated settlement agreement. All of the terms that are in the promissory note were in the mediated settlement agreement, and she did review that. So it's not because she didn't look at the note, which they emphasize very heavily, because there's really no distinction between those. Again, you mentioned the Rock Springs case, I believe.
Your time is up, so let me see if there's any other questions.
Yeah, I have one more question if I can, Chief. The claim in this case, the original claim, the substance of that claim was amounts due under this note. How is the amended claim that changes just the amount not a substantive change as opposed to change in form?
That is the distinction that this court made between changing the amount of a claim and submitting a claim for a new a new service rendered. That's the footnote 4 of the Scheer case, changing the amount. And what's most important is, if you drill down into that a bit, is that what's important is that the PR was on notice of what you're talking about. And here, there is no question the PR knew what we were talking about. We were talking about the note, and he knew to the penny what was due on that note. So there's no surprise there. And that's the First Union case, where there was they failed to ask for the default interest rate. And so they amended to add the default interest. Again, it increased the amount, but it was the same basic claim. It was apparent from the face of the note that it was due, and therefore that was viewed as a non-substantive change, just a change in form. So that's the basic difference.
All right, thank you, sir.
Thank you.
Any rebuttal?
Yes, Your Honor. With regard to the fiduciary duty of the PR, what the appellee is asking here would expand the duties of a personal representative beyond anything that any Florida court or the probate code contemplates. If a PR has the duty to investigate and make sure that a creditor asks for more or does everything right, that's not consistent with his other duties. Nobody would be a PR under those circumstances.
Let me switch topics here. If Gina had not, hired an attorney, and as a layperson, she didn't get the idea of maybe you factor the interest in first, or you factor the principal in first. She didn't understand that concept and made the mistake in the claim that was made. Would you view that as more excusable or more inexcusable, or the same level of lack of due care?
I would still find it inexcusable because she has all
Right, but that wasn't my question.
Oh,
Is it more inexcusable or less inexcusable than an attorney doing it?
I think perhaps less inexcusable than the attorney. Of course, this case involves attorneys, but both Gina and the attorneys had all the information they need. This is not a case where the PR had the exclusive knowledge that she didn't have, and he withheld that. They had the same information, or at least they could have had the same information if Ms. Van Sambeek had taken the time to look at it. And opposing counsel said that Ms. Van Sambeek did look at the mediated settlement agreement, but it's quite clear from her testimony that she only looked at portions of it that pertained to something else. And she admitted that she did not look at the repayment terms. And I would cite to 3 record pages. 1888, 1910, and 1932. And in each of those places, she talks about the limited review that she gave. And I think ultimately she admits she didn't look at the payment terms. And when the note was mentioned over and over, how could she not say, look, I want to see the note before we finalize this deal? She didn't.
Let me ask you quickly as to a different topic. There's pending motions for attorney fees. Obviously, if Gina's side wins, she's the prevailing party, attorney fees. Would the PR still get attorney fees if Gina wins this appeal because he's been required to defend it, or?
I believe that's what we have argued in the motion for fees.
Okay, and if your side wins, then Gina is not only out the 1.7 million plus their interest, but then she has to pay everybody's fees, PRs, the beneficiaries, the GAL's fees too. Is that your position too?
No, Gina doesn't have to pay it. I don't believe.
Well, it comes out of her share of the estate, right?
The estate, yeah, right, out of her share of the estate.
Okay, yeah, I agree. There's no judgment
Gina,
entered against
when
it.
we're talking about equities here, I think it's important to note that Gina has another adequate remedy should she lose this case, and that's a remedy against the lawyers who she retained to do this important matter and who admittedly didn't do their job. So at the end of the day, that's where equity should fall.
Well,
I think
that might be a broad use of equity, but I would just want to make sure I understood the lay of the land here, depending on who wins in the big.
Okay. Any other questions from the panel?
No, thank you.
And thank you both. Interesting case. We appreciate your arguments, and we'll be in recess till 11 o'clock.